5 seconds to go. Start. Sections 60 and 62 of the J&K Reorganization Act operate in different fields. Section 60 generally refers to the delimitation of constituencies, and Section 62 deals with the delimitation of constituencies on the basis of census figures of the 2011 census. He pointed out that subsection 1 of section 60, which confers power on the Election Commission of delimitation, uses the word may, whereas section 62 uses the word shall. The Election Commission, by a letter dated 2nd September 2019, informed the Government of India that since the Delimitation Commission is constituted under Section 62 of the J&K Reorganization Act, which is carrying out readjustment of parliamentary and legislative assembly constituencies, it was not necessary for the Election Commission to undertake the exercise under Section 60 of the Delimitation Act. Article 3 specifically empowers Parliament by law to form a new state union territory, and the said law referred to in Article 3 must provide for the appropriate amendments to the first schedule and fourth schedule for giving effect to the provisions of the law. Clause 2 of Article 4 specifically provides that no such law shall be deemed to be an amendment of the Constitution for the purpose of Article 368. Reliance was placed upon a decision of the Constitution Bench in the case of Mangal Singh and another versus Union of India on this behalf, and clauses 3 of Articles 81 and Article 170 do not apply to the Union territories at all. The learned senior counsel, appearing for the petitioners by way of rejoinder, urged that though there may not be any specific challenge in the present petition to the validity of the provisions of the J&K Reorganization Act, the said challenge can always be inferred. He submitted that the issues of inconsistency between the constitutional provisions and the provisions of the J&K Reorganization Act have not been answered by the learned Solicitor General of India. On 5th August 2019, the Constitution Application to Jammu and Kashmir Order 2019, for short, the 2019 Presidential Order, was promulgated by the Honorable President of India in the exercise of powers under Clause 1 of Article 370 of the Constitution of India. The said order was issued in concurrence with the government of the state of Jammu and Kashmir. Clause 2 of the 2019 Presidential Order provided that all the provisions of the Constitution of India, as amended from time to time, shall apply in relation to the state of Jammu and Kashmir, subject to exceptions and modifications set out in the said order. Clause 4 was added by the said order to Article 367 in relation to the state of Jammu and Kashmir, which provided that the expression Constituent Assembly of the state referred to in Clause 2 in the proviso to Clause 3 of Article 370 of the Constitution shall be read as Legislative Assembly of the state. The 2019 Presidential Order was brought into force with immediate effect. The second important development was the declaration under Clause 3 of Article 370 of the Constitution. For short, the said declaration made by the Honorable President on the recommendation of the Parliament. It was declared that from 6th August 2019, all clauses of Article 370 shall cease to be operative, subject to the exceptions incorporated in the said declaration. It was provided therein that, notwithstanding anything contained to the contrary in Articles 152 and 308, as well as any other article of the Constitution or any other provision of the Constitution of Jammu and Kashmir or any law, all the provisions of the Constitution of India as amended from time to time shall apply to the state of Jammu and Kashmir. Stop.